I wanted to thank you for joining our Cal OSHA Enforcement and Regulatory Update. Our firm has OSHA webinars throughout the year. This is one dedicated to Cal OSHA concerns, and boy, has there been a lot of activity in California this past year. So we are going to address the highlights. You know, obviously COVID has had a significant role in legislation and rulemaking in California. This will provide us an opportunity to discuss events beyond COVID-19 as well. I am in Long Beach, though if you see the view behind me, it looks like I'm in San Francisco, our other office, so we are aligned with the fog. I'm pleased to be joined by my colleagues, Fred Walter and Megan Shickhead. I do need to mention, this always comes up, is that we will have slides and a recording of the webinar that will be emailed to you all after the presentation today. So that will be coming your way. And if you have any questions throughout the webinar, type them into the chat function. We will likely just reserve those questions and answer as many as we can towards the end of the webinar. But I'd like to introduce myself first. I am a partner at Conn-Maciel Carey. My focus is Cal OSHA and other state plan enforcement, as well as employment litigation defense at the state and the federal court level, as well as counseling employers on employment-related concerns, whether it relates to workplace safety or other areas of employment law. And I've been practicing for about 25 years in California. And now I'll turn it over to Fred.
Hi, I'm Fred Walter. I've been of counsel at Conn-Maciel for a year and a half now, and I've been doing Cal OSHA defense work for upwards of 30 years.
Hi everyone, I'm Megan Shickhead. I'm an associate in our California office. I'm up in San Francisco area, and I am in the firm's both the employment practice, handling labor and employment matters, both litigation and advice and counsel for our clients. And then I'm also handling Cal OSHA matters with our OSHA practice, both handling administrative matters with the agency and advising on all things health and safety, particularly COVID-19 in recent years, but also everything else that, that comes up in those cases. I'm excited to talk to you all today.
So as for the agenda today, we have several different topics. We're going to start off with the discussion of the Cal OSHA COVID-19 ETS, and there have been a number of developments through various iterations of the ETS, the emergency rule. I'll walk you through the key highlights and recent changes, and there's been a number of them. Megan's going to discuss the 2022 COVID-19 Supplemental Paid Sick Leave that was recently passed by the legislature, as well as the warehouse and pharmacy quota legislation that took effect at the beginning of the year. Fred's going to address Senate Bill 606, which is a very significant development, substantially expanding the authority of the Division of Occupational Safety and Health. And he will discuss as well as the status of enforcement, and then we'll cover some highlights with case updates that you may be interested in. Then moving to the first subject, this is the COVID-19 Emergency Temporary Standard. There's quite a bit of content here. We have had webinars in the past focused only on the ETS because it's been so significant. This rule, as you may remember, caused quite a bit of whiplash by employers because it was enacted rather swiftly with many pages of content that, quite frankly, DOSH and the agencies did not fully comprehend, and of course, nor did employers. And so we've really struggled collectively in understanding what these mandates were, and then over time, there were readoptions that changed content to the rule. And so just a general background to give you a sense of how we got to the place we are today is the Standards Board, the Cal Standards Board developed workplace safety rules, and they considered a petition by a labor-oriented group, WorkSafe, They voted on it in September of 2020, granting the petition. And then emergency temporary standard for COVID, the one that was, I think we found it was maybe around 23 pages in content when printed, and it took effect at the end of November 2020. So there was a bunch of angst around that time trying to figure out what the obligations were and how the rule would be enforced. And then the agency convened an advisory committee to consider revised changes, as there was a recognition that there were areas that certainly needed to be corrected, just alone based on ambiguity, as well as changes in the pandemic developments that caused a reconsideration of some of that language. We did serve on that advisory committee. That advisory committee consisted of stakeholders, labor representatives, as well as agency or public health officials. And then eventually there was a first readoption of the ETS. There was a bit of back and forth before we got to that point of having that draft. That first readopted ETS or emergency rule took effect in June 2021. And that there were some significant changes, particularly around physical distancing, masking, testing, and a differentiation between vaccinated and unvaccinated employees, whereas there wasn't a contemplation of vaccination under the first draft. And then just most recently on January 14th of this year, there was a second readopted ETS. And so I'm going to cover the highlights of the second readopted ETS and some developments since then. That second readopted emergency rule will remain in effect until May 6th of this year. There is authority based on executive order for the ETS to remain in effect until the end of this year as an emergency rule. And so we expect there to be a revised version of the ETS issued by DOSH, the Division of Occupational Safety and Health, shortly. And they keep saying it's issuing soon. We don't know when. And we will certainly blog on that when it does issue. But right now we don't know what's going to happen as of May when there needs to be a new draft. So we'll see. We'll cover that a little bit later in the webinar. So moving right to the ETS, just as a refresher, the emergency rule for COVID applies to all places of employment. So it's a rather broad application. The major carve-outs are for employees who work from home or other locations of their choice, or otherwise don't have contact with others. And it's also employees that are subject to the aerosol transmittable diseases standard, which is specific to the healthcare industry. And what's a really significant consideration here is that the ETS is not intended to override public health guidance. So there can be more protective local or state public health guidance or mandates that would be followed despite the ETS. And we've seen that particularly in recent months over masking. And then moving further, just as another recap, the COVID-19 prevention program requires this multi-pronged program, somewhat similar to injury and illness prevention program, where you're required to establish, implement, and maintain this program that contains various different elements. And those elements include communication to employees, identification and correction of COVID-19 related hazards, investigating COVID cases, inspecting sources of infection, correcting those hazards, as I mentioned, and training of employees on different subjects. So let's move to the next slide, which addresses responding to COVID-19 cases. And this again, is really a recap, but there are certain actions an employer needs to do when they identify a COVID-19 case in the workplace and they identify the close contacts of that individual that tests positive for COVID. But there is a parallel track where an employer is required within one business day to give notice of the positive case, the COVID-19 case, excuse me. And they need to give that notice without revealing personal identifying information. And that information is very broadly given to individuals that are at the same work site as the COVID-19 case during the high-risk exposure period. So you give that notice to the employees in the workplace. You give notice to independent contractors and other employers that are on the premises, and you also give notice to the union of where any COVID case is represented. And then an employer is required to investigate the COVID cases and determine possible work-related factors. And then there's also, on the next slide, is there was legislation that, let's move to the next slide. There is legislation that passed. It's AB 685, and this was from a prior year. And there was an amendment to that language with some tinkering of the language. That amendment was largely incorporated into the ETS. So now AB 685, and as amended by AB 654, is aligned with the ETS, or the ETS is aligned with that law. And the major changes to AB 685 through that amendment as of this year involve outbreak reporting, and the requirement now is to report the outbreak within 48 hours or 1 business day, whichever is later. And that's when you meet the triggering criteria under California Department of Public Health criteria for reporting the outbreak. There's some industries that are exempt from outbreak reporting, largely because they're otherwise regulated statewide. And then there's covered, and I think the last point is not so significant. Well, let's move to the next slide that addresses COVID-19 testing. And a significant change in the ETS under the second readoption that took effect in January related to COVID testing. And the requirement is essentially that employers must offer COVID testing at no cost during paid time to all employees having a close contact in the workplace. So a close contact would be that you're the employee is within 6 feet, for a minimum period of time during the workday, and that would be deemed a close contact. And the revised ETS adopted language from the federal ETS on vaccination or testing that has since been withdrawn based on the Supreme Court ruling. And so there were requirements in that federal ETS on the COVID-19 testing that have been incorporated into the Cal OSHA ETS, notwithstanding that the federal OSHA ETS is no longer around. And so those requirements are that the testing cannot be both self-administered and self-read unless observed by the employer or an authorized telehealth proctor. And so that's caused great consternation by employers because especially in December, January, when we had a number of Omicron cases in the workplace, in the community at large, really, and there wasn't the bandwidth by many employers to be observing the testing. And so there is a recognition if it's a date stamped test that doesn't need to be observed by the employer. But otherwise, if you're looking at an over-the-counter test, largely that would have to be observed in some form by the employer. And there's really a lack of clarity about what that specifically means. How does it have to be observed by the employer? Can it be done by video? Can it be done by photograph? There's considerable debate about that process. But if tests are processed by a laboratory, there's no requirement for employer observation, or if the test is proctored over the counter. And then there's another option is for a test is when the specimen collection processing is either done or observed by an employer. So that would be a situation where the employer may have testing done on site that it is conducting, or where it is otherwise observing the employee's own testing, which could be off-site somewhere. So moving on, for physical distancing, just as a refresher here, physical distancing is no longer required under the ETS generally. However, where there is an outbreak, the employer must consider whether to implement physical distancing, that is, have some sort of evaluation about the need for that, and must otherwise implement physical distancing when there is a major outbreak. And so the outbreak provisions under the ETS are alive and well, and employers should be conducting an assessment when there is what may amount to an outbreak based on the number of COVID-19 cases in the workplace within a specific work group. So moving to face coverings, that's been an area where there have been significant changes. There has been a requirement, from the beginning in the ETS for all employees to wear face coverings. That was updated in the ETS to only apply to unvaccinated workers, and then now there was a California Department of Public Health guidance in recent months that required face coverings given the Omicron outbreaks in the community, and that applied to all workers. And in light of continuing public health guidance and the state of the pandemic, there has been a lifting of that mask mandate by the California Department of Public Health as of February 28th, except in certain high-risk settings, such as healthcare. And there is an executive order that issued as well on February 28th, so this was just a couple weeks ago, that suspended the generalized mask mandate for unvaccinated employees for indoor settings or when in employer-provided vehicles. The exception here, and it's important to note, is there may still be a mask requirement if you are in an outbreak situation or where there is healthcare screenings that are being conducted, meaning that if an employee is entering the workplace and subject to a screening, that during that period they would be expected to wear a face covering. So that's a really significant change that just took effect. So moving on, respirators. That requirement has not been repealed. And the requirement is essentially that upon request, employers must provide respirators for voluntary use to unvaccinated employees working indoors or in vehicles with others, and that this must be done as soon as possible. So there have been some former FAQs on the subject. I'm going to gloss over this since this is a subject we've just discussed in prior webinars and it's an existing requirement, not necessarily a new development, but it's just the takeaway here is that there is an expectation to promptly provide employees, face coverings, upon request. So that means that you will need to have in stock face coverings with the appropriate or the correct size and type to meet that demand. And one way to approach this based on former frequently asked questions posted by DOSH would be to stockpile the respirators so that they're in stock for when there is a request, or to send an email to employees as an example, or some sort of notice asking that employees let you know if they do have a need for those respirators. And a respirator, we're really talking about not a face covering, but an N95 respirator. And so given the state of the pandemic presently, there may not be that many requests. This could change if we have a further variant or a evolution of the pandemic where the circumstances change. So moving on to exclusion COVID cases and employees who had close contacts from the workplace. I want to spend a little bit more time discussing this issue. This has been an area that has been evolving rather rapidly during the pandemic under the ETS. There have been some changes to the ETS. Specifically, I'm going to talk about first the ETS and significant exception to that written into the ETS, as well as the California Department of Public Health guidance that supersedes the ETS to a degree, and that just issued where there's been a revised version from early January. So one significant exception. So let me first state that there is a requirement to exclude, obviously a positive case from the workplace for a certain number of days. There's also a requirement to exclude employees who have experienced a close contact in the workplace. So these are individuals that are not COVID cases. They're not positive as far as we know, but they had a close contact in the workplace with an employee that was positive. So in this situation, there are some exceptions to the exclusion requirement that these individuals be excluded from the workplace, and that applies to employees that were fully vaccinated before the close contact and do not develop COVID-19 symptoms, as well as individuals that had recently, generally speaking, within a 90-day period prior to that close contact, tested positive for COVID-19 and recovered from it. But these exceptions only apply if employees wear face coverings and physically distance for 14 days following the close contact. And this has been a tricky exception to meet because it's very difficult for an employee to fully physically distance in the workplace. So it's just an exception that's just not available to many employers. And so if an employer does not meet these exceptions for close contacts, then what you will want to do is follow the recommendations of the California Department of Public Health, which are covered in the next slide. So let's move to that. Well, let's first discuss exclusion pay generally. The significance of excluding workers is obviously you don't have your labor in the workforce, and that's created a number of issues in the exclusion of close contacts to the ability to continue to operate a business. And there has been some relief to them. They'll be covered in the next slide. But going to the issue of exclusion pay, the really significant concern is there's an obligation to continue to pay employees that have been excluded. And the obligation is to pay wages and continue benefits and maintain seniority while the employees are excluded. And there is not an obligation to provide exclusion pay where an employee experiences a close contact and the employer can establish that the employee's exposure was not work-related, but the burden's on the employer to show that. And exclusion pay is also not required where the employee receives disability payments or is covered by workers' compensation. A very significant consideration over exclusion pay is that it is subject to enforcement through procedures available under existing law. And so what that means is not only can you be cited by OSHA for not providing exclusion pay, more significantly, you can be subject to a wage and hour lawsuit. It can be individual or class action over not providing exclusion pay. So, we highly recommend consulting with counsel over the exclusion pay issues when they arise before making a general determination that impacts your workforce. So let's move to the California Department of Public Health guidance. So as a backdrop, the reason why the public health guidance has an impact on the emergency rule is there was an executive order by Governor Newsom from December of 2020 that provides that the return to work periods are suspended to the extent they exceed any applicable quarantine or isolation period recommended by the California Department of Public Health. So to the extent that the public health guidance provides for an exclusion period and return to work criteria that is shorter than provided under the ETS, that the public health guidance will replace the ETS provisions effectively. So let's move to what the guidance is. So there was a very detailed set of guidance provided by the California Department of Public Health. There have been some frequently asked questions provided by DOSH on this. There's still quite a bit of ambiguity, but I just wanted to walk through with you the nuts and bolts of it. So there are two components here. There's isolation and there's quarantine. And isolation refers to someone that is excluded because they test positive for COVID, essentially. So where there is a positive case involving an employee, regardless of vaccination status, that person must be excluded from the workplace for at least 5 days under the public health guidance that's being followed. And then they can return after day 5 if they do not have symptoms, do not have COVID-19 related symptoms, and a diagnostic specimen collected on day 5 or later tests negative for COVID-19. And so that can be an issue where an employee continues to test positive for an extended period. The antigen tests are not as sensitive as the PCR tests, we all find. And if the employee cannot test or just simply declines to test, the employee cannot return to work for the full 10-day period. And after 10 days, they can return, provided that the employee does not have COVID-19 symptoms. If the employee is able to return to work within that period, so that would be from day 6 to day 15, day 6 to day 10, that employee must wear a face covering around others for that period. Now moving to quarantine periods, starting with the next slides, there's several different scenarios and they relate to vaccination. So if the employee is unvaccinated and has had a close contact, that employee must be excluded for at least 5 days after the close contact. And then the employee can return after day 5 if there is a negative test based on a specimen collected on day 5 or later. And of course, if the employee has no COVID-19 symptoms. And if the employee declines to test or just doesn't test for whatever reason, the employee cannot return to work until day 11. And the employee must not have any COVID-19 symptoms as a condition for returning. And like the scenario with the isolation period, the excluded employee must wear a face covering around others at work after returning through day 10, following the last exposure. And if the employee does develop symptoms and tests positive for COVID, then you follow the criteria for isolation from the prior slide. So let's move to the last two slides related to quarantine. So this applies to employees that are vaccinated. So this slide is specific to an employee who's vaccinated and is eligible for a booster, but has not been boosted. So in this scenario, the employees need to be excluded from work. Do not need to be excluded from work if asymptomatic, but must have a negative test 3 to 5 days after the last close contact. And if the employee declines to test, they can return to work after day 10, provided there are no symptoms. And again, the same requirement applies about wearing a face covering when returning to work within that 10-day period after the last COVID-19 exposure. And again, if the employee develops symptoms, the employee must be excluded pending the test results. If the employee tests positive for COVID, an employee must follow the isolation requirements from the first slide for positive cases. Now, on the last slide, that addresses the situation where an employee is vaccinated and receives the booster vaccine, or is just not booster eligible and has that close contact. So under this scenario, the employee does not need to be excluded from work at all following the close contact, as long as the employee is asymptomatic, and the employee must take a test for COVID-19 on day 5 after the exposure. The employee must wear a face covering during that 10-day period after the last exposure. The real dilemma here is there's no recognition in the guidance or in the frequently asked questions by the division about the employer's ability to require testing. So it really creates a quandary for employers about what to do. And essentially, conservatively, employers need to continue to exclude employees in many situations where they have not been tested, whether that be or whether it be because the employee simply just refuses or doesn't have a desire to be tested. So I think we can move on. So, I want to leave time for the other really important subjects we're covering, but there's a lot to talk about here. We can discuss them in the question and answer period at the end. What's important to note is the ETS is not the end all on COVID-19. It's important to continue to follow the frequently asked questions by DOSH. Those answers given do not technically have the force of law, but they are helpful in determining what position DOSH might take in enforcement as the enforcement agency. There's also important guidance that we'll need to continue to follow from the Department of Public Health, both on a local and a statewide level, as well as executive orders issued by the governor. And we expect that, assuming that the pandemic becomes endemic over time, that there may be actions taken by the governor dependent on inaction by the Standards Board in rulemaking to suspend certain requirements under the ETS. And so, lastly, wanted to address where we go from here. There was a permanent COVID rule that was proposed by DOSH, and there was a meeting of the advisory committee on this. It's not clear whether that permanent rule will ever take effect or whether there'll just be a further revision to the ETS. There is talk among the Standards Board of developing an infectious disease standard that would be permanent and applied to very broadly beyond COVID-19. And we'll see what comes of that. The concern by many in the employer community is that adopting a highly prescriptive standard such as the COVID-19 ETS is simply unmanageable, where the science and knowledge is evolving and the type of disease can be varying. And so if there is a generalized infectious disease standard, there is a desire by many that we have some flexibility in the rule that is adopted and how it is applied, and to have some sort of performance standard like the IIPP that affords employers flexibility in how they identify the hazard, how they correct it, and other measures that are taken. And along those lines, there was a petition by Western Steel Council to adopt a standard on an emergency basis that would be more performance-based and recognizing the guidance by the Department of Public Health. And I think there's a little bit more detail on the next slide, but the idea is really that the standard that has been proposed, and it's uncertain whether that standard will be considered by the board, but it would essentially create a ninth element of the IIPP that would focus on infectious diseases and recognize public health guidance as directing the actions that would be taken by the employer, as there is a thought by many that the public health guidance is more timely, is more aligned with the scientific knowledge as opposed to an ETS standard developed by the standards board that would be locked in stone and might not recognize evolving conditions. And so we'll see what happens with the Western Steel petition, or if the board independently considers some broad ETS that is focused, or permanent rule that's focused on infectious diseases generally. But we expect in the next month to have a better sense of where we're going. Okay, well, I'm going to turn it over to Megan to discuss the supplemental paid sick leave law.
Thanks, Andrew. So this might sound familiar, COVID-19 supplemental paid sick leave. We have a new iteration of it for 2022. And this is essentially a new allotment of supplemental paid sick leave that is apart from regular California sick leave and apart from the exclusion pay requirement in the ETS. So this supplemental COVID sick leave is it stems from a piece of legislation that was signed by the governor and impacts all employers in California with more than 25 employees. And it provides up to 80 hours of COVID-19 supplemental paid sick leave. And there are essentially two buckets of available time. There's one that is up to 80 hours of time for reasons that are related to COVID-19. And I'll discuss the details of that on the next slide. Oh, I'll forward, get us on the right slide for now. And then there's a second bucket of up to 40 hours. And that is specifically for essentially where you have a positive COVID-19, it's somebody testing positive for COVID-19. And like I said, this is above and beyond kind of regular California paid sick leave. And this is separate from any previous iterations of COVID-19 supplemental paid sick leave. So if you recall in past years, there was California and even local municipal laws that applied that required providing supplemental paid sick leave. This is separate. This is a brand new batch for 2022. The one caveat is if you do have employers or even municipalities that require continued supplemental paid sick leave into 2022, then you might be in a situation where your 2022 paid supplemental leave is, ideally compliant with both this 2022 legislation and whatever either company policy or local rule that you might be following. But if you had supplemental paid sick leave in 2020 or in 2021, this is a new bucket of time. And it went into effect January 19th, I believe, 2022, but it is retroactive back to January 1st of the year. And it continues through September 30th of 2022. So this is something that is in effect for the next few months. So that first bucket that I mentioned, qualifying reasons related to COVID-19, covers things like an employee who's experiencing symptoms of COVID-19 and is waiting to get their diagnosis back, or an employee who has to take time off because their child's school gets shut down because of a COVID-19 outbreak. There's also specific eligibility for attending COVID-19 vaccine appointments, for either the employee or for taking family members they're caring for, and even experiencing symptoms from that vaccine. There's also a few additional eligibility categories, like, subject to a specific isolation order or, being ordered by a healthcare provider to isolate or quarantine. And then the second bucket of time is where you have a positive test. And this applies for the employee or a family member for whom the employee is providing care. And when we're in this category of time, the employer is allowed to require the employee to submit a second test after the first positive test. They're allowed to ask for a second test after the 5th day and provide documentation of the result. The testing does need to be provided at no cost to the employee, but if the employee essentially refuses to take that second test or refuses to provide the documentation, then the employer is under no obligation to continue to provide that supplemental time past that period of time. The time calculation is pretty simple. If you treat the employee as full-time, then they are eligible for up to 40 hours available for each bucket of time for a total of 80 hours. If they are working less than that, then the calculation differs depending on the amount of time that they're working. There are also some subject matter differences. If you have firefighters, there's a different calculation for that. And then the kind of wage and hour piece of this that's important to note is that if you're familiar with the wage statements, they list in California the bucket of time that's available for kind of regular paid sick leave that's required in California. This legislation now requires a second, essentially a second line item that specifically identifies the available time for COVID-19 supplemental paid sick leave. So you'll want to make sure that you're adding a new item on the wage statements that identifies the available time under this legislation. Now there is, like in previous iterations of California supplemental paid sick leave, there is a payment cap at $511 a day or $5,110 total. And if just another note on the retroactivity and how that works, if an employee makes an oral or written request for retroactive payment, then the legislation specifies when that payment needs to be made following that request. Now, the Department of Industrial Relations has updated their website since the legislation first went into effect, and you can now find model notices and many frequently asked questions to clarify some of the questions around the edges of this legislation. And so that's a helpful resource to look at if there are questions. It did take some time to update these. So there were some frequently asked questions both on the Cal OSHA ETS side and on the just regular DIR website for supplemental paid sick leave that had old references to 2021 supplemental paid sick leave. Those are being updated and addressed so that the frequently asked questions are better applicable to this current legislation that's in effect. So that's the supplemental paid sick leave. And then the second topic that I'm going to be talking about today are these quota laws that went into effect. There's one for the warehouse industry and one for a limited number of pharmacy type businesses. And these are, put very specific restrictions on quotas themselves and then the rights of employees related to those quotas. So the first one comes out of Assembly Bill 701. And this is a warehouse distribution focus. So this applies to warehouse distribution centers. And the backstory on this is that if you do any research on this legislation, there's really no, it's very public that this was designed to address concerns and that Amazon warehouses had quotas that were preventing employees, or this is supposed to address the concern that quotas may be preventing employees from taking meal and rest breaks, using bathroom facilities, or complying with occupational health and safety laws. So this legislation, which went into effect January 1 of 2022, requires employers disclose a written description of any quota that applies to a warehouse employee. There's a specific amount of time that employers have to disclose that written quota. And then the quota themselves cannot prevent an employee from, like I said, taking meal and rest periods, using bathroom facilities, or complying with other occupational health and safety laws. And if a quota violates this legislation, then an employer is not permitted to take adverse employment action against an employee based on that quota. So they can't enforce essentially an illegal quota. So the quotas themselves have to be compliant, and they have to be disclosed to employees. And then employees are, in addition to that, allowed to ask for copies of the quota information as well as their own personal work data. So the information that would show whether or not they're and how they are complying with the quota.
Megan, if I could just add that, this clearly has a political motivation, this legislation, and the claim by the proponents of the legislation is that there is a need to curtail these workplace quotas that are allegedly interfering with the ability of employees to take meal and rest breaks, or otherwise interfering with workplace safety standards. But the reality is that, at least what we've been seeing is that, most employers in warehouse settings, if they have any sort of quota, it's designed in a way that doesn't interfere, that excludes meal and rest breaks from the quota, and is designed to ensure that the workplace safety conditions are adhered to. But the real significant aspect of this law, in my mind, is really the retaliation component, and creating a presumption of retaliation where there's a complaint related to quotas. So you have an employee that says, they could be coached by someone, it could be by an attorney or otherwise, or by a union, to complain about the quotas. And then they're fired, say, for performance reasons, and all of a sudden there's a presumption of retaliation, and it's the employer's burden there then to rebut that presumption. So to me, that's the most significant aspect that's deeply troubling.
Thanks, Andrew. Yeah, that's definitely the big concern here, because there is that. It's rebuttable, but there is a presumption of retaliation. And it exists basically anytime an employee exercises any protected activity under the law, and it's within a 90-day period of time. And engaging in protected activity, an obvious example of that is a direct complaint about the quota, right? But it could also be as simple as requesting information about the quota, or requesting an employee requesting they call it the personal work speed data. So if somebody makes a simple request, hey, can I, get a copy of the quota that applies, or hey, I want to see what my work speed data looks like, that's also considered a protected activity under the law. And there's a certain employers have 21 days to respond to a request for information under this law. And the kind of relief that is provided employees if they were to bring a claim under this is they're permitted to request injunctive relief, to presumably request a change in the quota. Attorney's fees are available for prevailing on a claim under this law. And the one that always makes our ears perk up on this side in what we do is PAGA penalties. And PAGA penalties are where an employee essentially brings a representative action, not a class action, but a representative action on behalf of similarly aggrieved employees. So in this case, it would be on behalf of the other employees who are subject to the quota. And that representative employee is permitted to request penalties on behalf of that group of employees. So since, in theory, warehouse distribution centers, would have, especially under the definition of who applies to this law, it's larger employers. So, people who might be looking out for whether this, paying attention to this law, those PAGA cases are something that we're keeping an eye on as well. And then the second quota law that came into existence was for a very specific group of pharmacies. They call them chain community pharmacies under the law. It's where there's a chain of 75 or more stores in California under the same ownership. And here they've essentially prohibited from being a quota at all related to the duties for which a pharmacist or a pharmacy technician license is required. So essentially no quotas for a pharmacist or a pharmacy tech. And it appears that this is out of a concern that given the high demand for COVID-19 testing and vaccines, that there, perhaps is a concern that mistakes might be made if there were quotas in place. Although again, there is clearly some political motivations behind this as well. But this one, rather than defining what a quota has to be, here there's just a blanket prohibition against quotas in this context. And with that, I believe Fred is going to be discussing Senate Bill 606, which will take us back to discussion of Cal OSHA. So I will turn it over to Fred.
Great. I want to talk about this law because it's going to be, it represents a trend in enforcement. It represents an intrusion of the legislature into Cal OSHA to a greater extent than we've seen before. On the one hand, prior to this, the legislature would pass a law, then send it off to the Department of Industrial Relations and say, make a regulation out of this. And then you would get into the standards board's bailiwick, and you would go to meetings of advisory groups and draft out the language that was a consensus between labor and the division and employers. Here, in this law, the legislature specifically said that the labor code, this provision of the labor code, can be enforced directly by Cal OSHA. They don't have to go through that process. And so, according to the language of 606, if you can establish an enterprise-wide violation of either a written policy or procedure of the board, think IIPP, heat illness, and the rest, or evidence of a pattern or practice of the same violation in more than one workplace, then you're on your road to an enterprise-wide citation. Next slide, please. That's the first part of the rule. The second part is where you can prove that the violation was egregious, and that's a new word in the lexicon of Cal OSHA. Egregious employers that willfully violate a regulation allows for the issuance of separate citations and penalties, not just for each violation, but for each employee who they claim is exposed. And the definition of egregious is pretty broad. And I have to believe that the language was chosen not because it was carefully drafted, but because they wanted the vaguest kind of language allowed. So, for example, one category of egregious behavior is the existence of persistently high rates of injury. What that means is left for the attorneys to decide. Another one is an extensive history of past violations. Of this part, I'm not quite sure what of this part means. Part is a phrase I've seen used to deal with federal regulations, but not California statutes. Next slide, please. Intentional disregard and clear bad faith and a large number of violations. All of these are so vague and subjective that could lead to a lot of litigation. There is one last category, however, that I think the division is going to fix on, and that is intentional known violation with no reasonable effort to eliminate the violation. This is one of two tests that the division uses to tag an employer as having committed a willful violation. And I think that they're going to try to get a twofer here. They're going to try to take a citation that in reason could be seen to have been willful and drag it up into egregious and use that. Now, you've got to understand that the division moves slowly, and for reasons we'll mention in a couple of minutes. They're not used to the idea of enforcing labor code sections. They're far more used to enforcing Title VIII regulations. So they've been slow in the uptake. We haven't seen any evidence that they're putting SB 606 into practice. I'm sure they're still in the analysis and training mode, but it's something that is just an early warning of some likelihood you'll see down the line. Next slide. Okay. So it gives OSHA new jurisdiction. It gives them the right to cite under the Health and Safety Code as well as the Labor Code here. The rebuttable presumption, again, as Megan discussed, rebuttable presumption of retaliation is there whenever an adverse action, whatever that might be, is taken against an employee within 90 days of the employer either disclosing positive tests for a communicable disease, not just COVID, asking for testing as a result of an exposure, requesting PPE that is, quote, reasonable under the circumstances, or reporting a possible violation of a safety regulation. That one already exists, but we have these others to include here as well. Next slide, please. The reason, go to the next slide then. I wanted to jump in, and we have a few minutes remaining. I wanted to jump in and talk about the division's status. Next slide, please. This, by the way, stay here for a minute. This information, as you can see, is 2 years out of date, but the line to look at are letter responses. These are complaint letters that the division receives from employees or the public, for that matter, or ex-employees. And between 2019 and 2020, it jumped by about 50%, a little under 40%. That's a trend that we're seeing continuing in this year. Next slide, please. You may not believe it, but the agency, although it's gotten back into hiring mode, still has an inspection or inspector vacancy rate of almost 30%. And this is taken as egregious by, to use a better phrase, by labor, because in California, the rate of inspectors to workers is 1 to 95,000. You'd not believe it by the number of citations that are written, but that's it. And they also compare us to Oregon and Washington, which have far lower rates. So given that our new OSHA chief is coming from Washington State, I think we're going to see a ramped up effort to hire inspectors and get them into the field. Those inspectors that are hired are probably right out of university or college with no real world experience. It used to be that the hiring would be of, it was kind of a retirement position. You'd have a a career in industry. And then when you retired from that job, you would pick up a job working for Cal OSHA. So you would bring with you to Cal OSHA some experience in how the workplace works. This next one is interesting too. We have 7 district offices without managers. Last year, it was only 5. The legal unit has a vacancy of 58%, and they're hiring as fast as they can too. But those attorneys have no real experience that we've seen in handling Cal OSHA cases. Next slide. Of course, COVID-19 is the enforcement priority. COVID-19 related inspections since the early pandemic have increased maybe, but we're seeing them for the most part, as the next slide will show, in the areas of the IIPP 3203 as well as 3205. Next slide, please. And jump down to post-ETS, all of the above plus the ETS. As I said, we're seeing citations under IIPP and ETS citations. We're defending one case that has required us to go back and track, sometimes month by month, guidances that were available on the internet to employers in one county from their public health agency, and see whether the division is accurate in saying that there was a violation of local ordinances, local guidances, and the like. That's become a treasure hunt for data, both on the internet and locally, and then comparing all of that to the guidance information from Cal OSHA. And next slide, please. I think Andrew is taking over this part of the presentation.
I'll be very brief since we want to leave time for questions, but these are 2 significant decisions that came out recently, and Western Growers' decision. I think the takeaway, this is a case that where certain employer groups or trade organizations filed suit in the Superior Court in San Francisco seeking to enjoin the COVID-19 ETS, in part asserting that the Standards Board did not have authority in certain areas. There was a resounding kind of denial of that request in the Superior Court. It went up on appeal, and the appellate court essentially affirmed the ETS and the authority of the Standards Board. And I think the real takeaway there is that the extent to which the court has deferred to the Standards Board and granted it broad authority over emergency rulemaking will be felt not only with respect to the COVID-19 ETS, but other emergency rulemaking. So that has a major impact in how we proceed with workplace safety rules. And then, the Papich and Granite Construction decisions by the appeals board, that's the Cal OSHA appeals board, relate to valley fever virus. And the reason why we highlighted that case, it just shows that for the valley fever, there was a recognition that there could be violations under the IIPP and other safety orders, meaning that there did not need to be a specific standard addressing valley fever for the division to be able to cite employers relating to this potential hazard to the extent it's tied to the workplace. And so, this is a case that we've really focused on in showing that for COVID-19, we didn't need to have a emergency temporary standard, and that there was the ability to enforce and cite employers under the IIPP, which is performance-based and has a little bit more flexibility for employers in terms of how they comply as the pandemic is evolving. So let's turn to some of the questions here. I think that's the end of the presentation. There was one question I think may be appropriate for Megan, and the question was, if an employee who has tested positive and used up to 40 hours in the second bucket, which I'm assuming that this is referring to the second bucket of supplemental paid sick leave. And the question is, can that individual then dip into the first bucket when the employee gets COVID again?
So no, that's why there's these two buckets. So you have to, so if you essentially use up the time for one bucket, you can't dip into the other bucket if that's still available. You have to essentially meet one of the qualifying reasons for the first bucket or second bucket. It's not a general allotment of 80 hours for any of those reasons. It's specifically divided for up to 40 hours for the one category of reasons and up to 40 hours for the second category of reasons.
And there was a question about exclusion pay. Is there a limit on the number of days an employee has to provide such pay? And there is a limit, and I believe it's 10 days. It's for a positive case as well as a individual has had a close contact and subject to the exceptions under the ETS as well as under the California Department of Public Health guidance. But this may be a good opportunity to explain the interface between the supplemental paid sick leave and the ETS. Megan, did you want to address that too?
Sure. So the overarching thing to keep in mind is that the ETS provides for exclusion pay for certain situations, essentially, COVID-19 positive cases and those who had workplace exposures to COVID-19. So you're essentially taking the employees who have the COVID-19 or those who may have been exposed and may turn positive out of the workplace, so that you're protecting the workplace from essentially additional infection. And so that's what the ETS is focused on. Paid supplemental leave, as far as we can tell, is intended to kind of fill a gap where there wouldn't be an ability for employees to be paid under the ETS, that there's this other bucket of paid leave that employees can pull from. So, there's no allotment under the ETS for, paid time off to go get your vaccination. So that would be covered by paid supplemental sick leave. And we've gotten a lot of questions about how to deal with both of those together, because a lot of questions under the ETS, as you know, and as we can tell by the number of questions that we're still getting, is that there are a lot of things that are not crystal clear under the ETS. And so we do continue to see a lot of questions in these areas about how these two interact together. And there are, lots of questions that deal with that on both the ETS side and the just supplemental paid sick leave for the frequently asked questions that the division is trying to put out to try to clarify some of those questions.
And unfortunately, the ETS exclusion pay cannot be applied to meet obligations under the supplemental paid sick leave law. So that's creating considerable concern by employers. There was another question about, is the mask mandate in the ETS still applicable with regards to employer provided transportation? The employer transportation section incorporates the provision from the general ETS on the masking requirement. So therefore, based on the executive order by the governor, there is not a general requirement for masking authorizing an employer-provided transportation as of the present. There was also a question about the impact of Senate Bill 606 and what to expect in enforcement of enterprise-wide citations, meaning how that would be seized upon by the division. Fred, is that a question you would like to chime in on?
Yeah, I will. And one of the drawbacks of working remotely is that sometimes your dogs come to work with you, so you might hear something in the background. As far as enterprise-wide goes, that's a good question. I think the enforcement is going to, I think enforcement is going to come from a co-show or an inspector who not just targets a store or a company with a number of outlets, but in investigations when they come across a problem with a written program, for example, IIPP or heat illness, and then they will look further. I think that the way to prevent that, of course, is to ensure that your written programs are as bulletproof and compliant as possible. And where you have where you've allowed stores or other outlets to craft their own variants on your IIPP or heat illness program or the like, you should ensure that they also are compliant. It would be a good thing if you had programs that were compliant, but in different configurations or approaches, because that would downplay the idea that you have an establishment-wide issue. Did that answer the question?
I think so. I think so. I mean, I know Fred and I have discussed the low-hanging fruit. And so if you have a, from my perspective, if you have a written policy or procedure, that's something that's very easy for the division to seize upon and argue that that applies at various different locations. There's enterprise-wide violation. The other component on pattern and practice, that is more factual and requires digging by the division. So, my recommendation, at least for many employers, has been to, but my recommendation has been to at least initially really focus on your safety policies and procedures, conduct an internal audit, look at the policies that may have compliance issues based on the face of the document, and then you move to broader issues relating to pattern and practice. There's a lot to consider. There was a question that about how long do you anticipate these requirements being in place? California is really the only state in the nation with such strict rules around quarantine, isolation, testing, and supplemental pay. And that's a really good question. I mean, we've attended many of the standards board meetings, and that's the board that engages in rulemaking over workplace safety issues, including the ETS. And they've really, as a whole, been quite resistant to repealing the ETS. And we're doing all we can to move the standards board in the right direction. But it may be that the emergency rule remains in effect for some time. There is the prospect of the governor stepping in and repealing certain portions. There may be pressure from the governor's office for the standards board to take a more aggressive stance, as the pandemic turns into an endemic, hopefully. And so, my sense is that for now, for the end of the year, we're likely to see a continued ETS over COVID, maybe in a more scaled back form, and that it may ultimately be replaced with a broader infectious disease standard. But we'll continue to blog on these. We are serving on the advisory committee over this, but we're hopeful that there will be further progression, because it does seem that we're out of step. There's a number of requirements that have been scaled back, but there are others that just remain in effect and, frankly, don't make a lot of sense to continue to apply at this stage of the pandemic. And so with that, let's see if there's anything else we might have time for. One more question.
Well, Andrew's looking for that other question. I'd chime in to say that there's a lot to the ETS that really should be challenged legally. I think there are questions of constitutionality and overreach that haven't been addressed yet.
So the problem is that some of them have been addressed in the Western growers case, and so we just don't have a receptive court system here in California, unfortunately. But you know, we're doing the best we can, and we have a very activist legislature as well as standards board presently, and so it's in contrast with many other states in the nation generally, and that's why we have so much legislation and rulemaking here. That's my mini diatribe, I suppose. I tried to refrain from that. But with that, we're going to end the webinar, and you can certainly feel free to reach out to any of us with any other questions you have, and we'll continue to blog on these developments. And we expect that shortly we'll have that revised ETS, and that will provide further information on that. Thank you again for participating. We've highlighted our blogs on the screen. We have employment blog, OSHA, general OSHA blog, as well as a Cal OSHA specific blog. And then we have webinars throughout the year, and there's a further series listed here. This is, I believe, on employment issues. No, this is the OSHA webinar series. So we have webinars essentially monthly on various different subjects. And we hope you join us again. Thank you.